Welcome to the Ohio Eviction Playbook.
Hey everyone, welcome into an all-new episode of the Ohio Eviction Playbook with Ed Kasputis. I am your host, Mike Leon. You know, Ed here is a longtime Ohio attorney. He's a former state legislator, and he's the founder of Kasputis Law Firm, and he approaches these evictions through both a legal and a business lens, helping landlords and investors avoid these costly mistakes. Today's episode, we're going to take you step by step and talk about how evictions actually work in the state of Ohio. Ed, it's good to see you. Happy New Year to you and yours. So let me ask you at a high level here, what is an eviction action under Ohio landlord tenant law? What's it designed to determine? What are the issues that are outside the scope of an eviction case?
Thanks for having me, Mike. The eviction process in Ohio was developed in 1974, the Ohio Landlord Tenant Act. And the bottom line is, who has the present right to possess a rental property? So when you go to court, the judge is determining who presently owns it. For example, someone might say, my grandmother died, I'm living in her house, down the road I'm going to inherit the house. But the judge will say, yeah, but who has the present right? Right now, it's the executor. The executor might have to sell the house to pay bills. So you don't have a present right, even though you could be a future heir. You have to leave. The bottom line is this. The Ohio Landlord Tenant Act was created for residential evictions so that there's no breach of the peace. If you need someone to leave and they won't voluntarily leave, you must go to court and have a judicial proceeding instead of fighting on a front porch or in a parking lot.
You know, Ed, can I harp on something that you said there? And it's really around when the court focuses solely on the right to the immediate possession of the property. How is that treated differently from questions of ownership or title?
Well, questions of ownership or title, you can have a quiet title action where you can determine that. But right now, if we were in eviction court this very second, the court's going to look at the county auditor website and say, who owns the house right now? Well, according to the official government records, it's Joe Blow. Then Joe Blow owns the house. Now, does he have a legitimate reason to evict you? Have you not paid the rent? Do you not have a lease? There's a concept called no color of title. I'm not the owner. I don't have a lease. I'm a guest. They want me to leave. I gotta leave. So the court's always focusing on the present. And if you want a long out fight on who owns the property down the road, fine. You can go to the court of common pleas. But 98% of all evictions, at least in my practical experience, are in municipal courts. Ohio has a two-court system, municipal courts and common pleas courts. And the municipal courts do evictions every day, and they're pretty good on the fine points of the law.
Ed, let me ask you, because you mentioned a few in there, but are those the most common grounds that you've seen throughout your practice or that are obviously instituted that allow a landlord to file an eviction in Ohio? Are there other types of things that we don't even know about?
Well, let's see. Non-payment of rent's probably the big one. Your lease is expired is another one. Let's say you have a month-to-month tenant. You give them 30 days notice saying, I want you to leave. Why? I don't have to tell you. I might want to sell the property. I might want to renovate the property and I need the property vacant. I might want to move in a family member. Those are the common ones. No color of title. That's kind of growing. I will have family members come in and say, we've got a 40-year-old son who has failed to launch. He just won't leave. We've got to get him out. Well, under Ohio Landlord Tenant Act, we have to give them a 3-day notice saying you have no color of title and you need to leave. Those are basically the big ones. Unauthorized occupant. Think about it. You're a landlord. You're screening people. They pass your background check. Next thing you know, you blink. Who's Charles Manson? Why is he in my suite? Well, I snuck him in. I know, but I can't have Charles Manson. If I do, why am I checking people's backgrounds? He's an unauthorized occupant. He has to go. I'm evicting you for bringing in an unauthorized occupant. Same thing with pets. We have no pets. And, one of the things landlords have to be careful of is when people start getting papers from doctors saying this is my service animal or my service donkey, and it's like, is it really? And I get those calls too, and that's a gray area. That's a little tough. If it's legitimately a service animal, that can overcome your no pet policy. But a lot of times when you really dig through the facts, it's just a pet.
Right. Well, if you're an Ohio landlord out there listening to this, you definitely want the pet versus Charles Manson. But we're going to leave that there for a second, Ed. So let me ask you something. I would love for you to kind of explain to the audience, because I know before an eviction can be filed, there's a 3-day notice rule or something like that. Can you kind of explain what that is and what role does that play under Ohio law?
The 3-day notice is the document that, in theory, gives the court the jurisdiction to hear the case. So if I'm a judge, the first thing I'm looking at is the 3-day notice defective. If it is, then I cannot hear the case. Now, in our law firm, probably the biggest thing we do, we're like carpenters. We're measuring wood 3 times before we cut it. We'll have landlords send us 3-day notices, and it's like, it's defective. We got to redo it. This is wrong. This is wrong. This is wrong. We got to make sure that's right, because my nightmare is 3 weeks later, I'm in court and we lose on a technicality, and the landlord goes, oh, why didn't you figure out my mistake earlier? So number one, you've got to have the proper name of the owner on the 3-day notice. Then you've got to have the proper name and address of the tenant that you're evicting. Then there's a concept called the statutory language. This is magical language that has to be on the 3-day, word for word, and more importantly, in the biggest font. The way a judge will analyze it is, when I pick up the 3-day notice, what's the first thing I see? It's supposed to be the statutory language. If the statutory language is the same font size as the rest, then any good attorney or a smart tenant can say the statutory language is not conspicuous. Therefore, the 3-day notice is defective. Therefore, you've got to throw the case out. So getting the 3-day notice correct is imperative, or we're wasting a lot of time. Because in Northeast Ohio, you file and you're still waiting 2, 3, sometimes 4 weeks to get a court date. And I'll have clients come to me saying, I tried it on my own and they threw it out. And now I need somebody to save me time. What is the value of someone occupying your rental property for 4 to 6 weeks without paying you? So I always tell them, the definition of a good attorney or a good accountant, they pay for themselves. Don't look at us as an expense, but as an investment. Time is money. We got to get the person out.
Hey, Ed, let me ask you, though, with respect to the 3-day notice, how does the timing of a 3-day notice work, particularly with respect to whether it be like business days, maybe that fall like around the holiday weekend? We just had a holiday weekend here. Do we give additional time to the tenant?
You do not count business days or federal holidays. So let's say a client serves it on a Monday. Tuesday, Wednesday, Thursday, you can file on Friday. Let's say they filed on a Thursday, but there's a legal holiday on Monday. Friday, Tuesday, Wednesday, file on Thursday.
Okay, so that's good to know. So now, after the notice period has expired and now the eviction is filed, what should the landlord or witness be prepared to establish at the preliminary court hearing?
Well, typically we prepare a complaint with exhibits, and they should be ready to talk about the exhibits. For example, if you're an eviction magistrate, you always say, how much is rent? And in a perfect world, your client knows off the top of their head and saying, let me fumble through the papers, I don't know. When was the last month they paid rent? How did you serve the 3-day notice? Here's a biggie. Whoever serves the 3-day notice has to go to court. So if Joe Blow is the owner, but he has his cousin Jim Blow serve the 3-day, now I need 2 witnesses. Joe to testify about non-payment of rent, and Jim that he served the 3-day. And then the magistrate will want to know, how did you serve it? Did you tape it to the door? Did you hand it to him? Did you hand it to his grandmother? Did you give it to an adult? Hopefully you didn't give it to a 5-year-old kid. That's a good way to say, no, not good service. And you just have to know your case. Many times I'm in court watching witnesses that they don't know what the rent is. They don't know when the last time they paid rent. Just very fundamental things that any good property manager or owner should know off the top of their head.
Ed, as we put a bow on today's episode, let's talk about once the court, rules in favor of the landlord. What are some steps that are required to regain possession of the property? How does that process vary depending upon the court?
Well, once you win, you need a writ of restitution. That's instructing the court that I'm going to need the bailiff to help me to move out people. And believe it or not, it varies among the courts. For example, in Cleveland Municipal Court, when you get an eviction, you have to purchase for $15 a writ of restitution. But if I took you to the Parma Municipal Court, when you evict someone, they're like, yeah, we got you covered. We're not charging you for a writ. They got 10 days to get out. If they don't, then call us and we'll come and help you. The move-out procedures are different from court to court. The more evictions you do, the more humble you get by saying, what is your procedure in this court? For example, in Cleveland Muni, if the bailiffs come out, you only have to put the tenant's belongings on the curb. But if you go to other courts like Garfield Heights or Euclid, they want you to put it in storage for 30 days at the landlord's expense. So it varies from court to court, which is the opposite of what I thought we accomplished when I was in the legislature, where you pass a law, you think it's going to get uniformly applied, and then you blink, and when you go to all these different courts, they just put a different flavor to it.
Well, Ed, we thank you for the time, the insights, breaking this all down for our audience. I appreciate it as always.
Thank you very much. Great having you.
And that's it for today's episode of the Ohio Eviction Playbook. Look, if you want to learn more about Ed's work helping landlords and real estate investors navigate these complex eviction issues in the state of Ohio, do me a favor right now, visit KaspudisLaw.com. Thanks for listening. But before you go, do me a favor, hit like, subscribe, leave a review or comment or share the episode with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.